Judge Cratsley, thank you very much for joining us today within the project 16 Minutes of ADR. Today, we're going to talk about judges, mediators, and arbitrators and how judges can promote ADR. So firstly, can you talk more about your experience in terms of developing ADR both in the court and outside the court?
Probably the most important thing we did in the Massachusetts state courts, now I'm going to talk mostly about our state courts because my years of working as a judge were in the state courts and not in the federal courts. But the most important thing we did was to initiate, with the blessing of our Supreme Judicial Court rules, we initiated the ADR screening concept so that cases were summoned into court prior to the final pretrial conference, somewhere after discovery had finished, possibly during motions practice, but for the specific purpose of discussing the usefulness, appropriateness, value of having a mediation or an arbitration for the case. And so attorneys were required. It was a mandated court appearance. And my version of this event was to give a speech about the value of mediation. I talked about it from a public policy point of view. I talked about it in terms of actually helping to speed the court dockets and make more room for other cases. And I talked about it from a practical point of view about saving time and money and client preferences and so on. And attorneys had to meet with me case by case by case on a list and tell me, are they interested in mediation? And if they're not, what is the barriers to mediation? So that was one very important step, was to create a mandatory screening. It was mandatory to come to it. You didn't have to agree that you would select a mediator and go forward, but you had to show up at the screening and you had to hear the speech. The second important step was for our Chief Justice to mandate that all of the final pretrial conferences, this would come later after the ADR screening, but assuming that hadn't worked, that the final pretrial conferences would be run by judges, not by clerks, and that in the agenda for that conference, in the rule that required what you had to talk about and had to bring a written report on, was the potential for mediation of the case, for some type of alternative dispute resolution to the case. The other approach to increasing judicial use of mediation is education, is simply having mediation presented at various judges' conferences. Also in the, you don't have to always have 100 judges in a room with a lecture. You can also do it in one courthouse with a group of 5 or 6 or 10 judges that are doing civil work. And way back when, in the beginning, we actually did some mock mediation, some abbreviated mock mediations to try to show the court what could be gained by a successful mediation.
Should the judge have a possibility to conduct mediation in the court? In some countries, there's no such possibility. In some countries, there is. And I know in the U.S. there has been tremendous experience in terms of letting the judges to mediate. Can you share your experience?
Yes. Yeah, I realize this is controversial. I actually wrote a law review article about it, recommending that, actually I recommended in that article that the Code of Judicial Ethics contain a provision that if you're unsuccessful as a judge mediator, you should not be the trial judge. Now that no state has ever adopted that, and in fact there's a rather well-written rebuttal to my point of view from a federal district court judge who read my law review article and published on one of the ADR blogs the other side of the story. My feeling why you should not be the trial judge for a case that you cannot you try to mediate and you can't get it done, it largely revolves around the judge's input in the mediation that affects the clients. When the clients, in our judicial mediations, the lawyers and clients are there. The clients are hearing the judge say, as you get closer and closer to settlement, well, you should pay so much money, or you should agree to such and such a terms. And the judge begins to put some pressure on one side or the other. And then if it doesn't work, and it's about to go to trial, I think the clients, maybe more than the lawyers, wonder if this person can really be fair. He just told me to pay $100,000, and I don't want to do it. Now he's going to run my trial. And especially if there's a jury trial, I think maybe he's going to make certain rulings along the way in the jury trial and if I begin to see it going against me, these rulings about who can be on the jury and the directed verdict and what kind of evidence gets in and how many questions we can ask our expert witnesses, and they start to go against me, I'm going to think that that's because I didn't do the settlement he recommended. So my feeling is it's a perception, it's a feeling of fairness for clients that why the judge should not should not go on and try the case after offering certain solutions and certain proposals and putting pressure on one side or the other.
One of my friends and also JAMS fellow was telling me a Bulgarian judge. He was sharing his experience that in Bulgaria the success rate of the cases was very low because the judges could not determine what is the right case for mediation. When you were a judge and you were referring cases for mediation, how could you understand that this is the right case for mediation?
Well, there's some traditional factors that have been mentioned for quite a few years. Family disputes are thought to be potential for mediation. Business disputes where the parties may have some future dealings with each other are thought to be good. But in having left the bench by retirement and now doing actively mediating, I've also observed that cases that are look like they're going to be extremely expensive and complicated are actually good cases to recommend to try mediation. I'm now seeing in my mediation practice cases that have been sitting in the courts for 1 to 2 years, spending a lot of money, doing a lot of motions, doing a lot of discovery, hiring experts, and the clients, I think, are becoming weary, tired of the expenses involved, and are of their own accord, of their own judgment, saying to their lawyers, I think, isn't there another way where we could try to resolve this in the day instead of waiting another year here in the court. So some of the cases that if I were back as a judge, I would be watching for those cases that look like they're very expensive and time-consuming and have real financial burdens on clients, and suggest to them wouldn't an approach where you were in charge of the outcome that was relatively inexpensive and could be accomplished in a day appeal to you as a way of getting a solution. These are mostly now, when I look at these complicated, expensive pieces of litigation, they're mostly business disputes. My recent mediations have been restaurant ownership dispute, real estate or real estate broker disputes, that type of thing. So I think there's a range of business disputes where business people who realize the expense and the time that's going to be involved in court can be encouraged to use mediation as an option. The only other approach that I think a judge can use is a conversation with the lawyers, where if you sense that the lawyers feel we can help you, we're open to the mediation, we're not fighting anymore, we're interested in seeing a mediated solution. Our clients may not be there yet, but we as attorneys want to participate in good faith in this mediation. And I think if you sense that in a conversation at the courthouse about some discovery motions or some other kind of issue that's brought the case in front of the judge, and the more you talk with the lawyers, the more you realize they are willing, they are interested, they want to help a mediation process. That's another good case. That's another good category. Lawyers ready to give this an honest try.
You are very active in terms of ADR. You're currently a neutral, a mediator and arbitrator with JAMS. You are teaching at Harvard Law School. And I know that you also mediate at the court. Can you share your experience and your view? What makes a good judge in terms of ADR?
One is you need to have some court structure, some court events that give you, as the judge promoting ADR and even promoting yourself as the mediator, the chance to intervene, to interject, to say, this is a good idea. So you've got to have either an ADR screening event, a pretrial conference event, or you have to be very sensitive in the motions practice to say to the parties, listen, this is a really long and expensive motion. Obviously, if I have to, I'll make the decisions, but maybe this is the right time to do mediation. So you have to be able, if you're a young judge interested in promoting mediation and doing it yourself, you've got to find the entry point into the case where you can inject yourself and inject your interest in helping the parties resolve the case. The second point that helps the young judge is when the senior judges or the chief justices are actually saying this is a good thing to do. We want you to inject yourself. We want you to promote ADR. We want you to become a mediating judge. And we will also, in our rulemaking, in our administrative structures, in our administrative rules and regulations, however we do leadership steps for the court, we're going to say that we want our judges to offer themselves as mediators and put themselves into the mediation stance.
Currently in Armenia we have a system which actually requires the judges to tell the parties about the possibility of mediation, and then it's up to the parties to decide whether they want to use mediation or not. However, not many cases are referred to mediation. Can you share your experience how we can fix this problem?
What we did here, it's a little different, but I think it could be adopted. When we did our Supreme Judicial Court rules for court-connected ADR, we wrote a new Rule 5 that required attorneys to sign a statement when they filed a case and when they filed an answer. They had to sign a court document at the clerk's office that they had discussed ADR with their client. Now, whether you could adopt that form so that every judge has to either sign it or get lawyers to sign it as an added step to just talking about it, you could then monitor whether these signed forms were being collected. And some, again, there's pushing ADR and promoting ADR within a court system does take judicial leadership. Obviously, it can be done by an individual judge who feels strongly. But a system to get judges to even sign a document, yes, I spoke with the parties at my first event with them. I don't know what the first event would be in Armenia, but some type of early conference. Signing it, yes, I told them about ADR, and maybe the lawyers sign it and the judge signs it, and then it goes in the docket. And then people that care about measuring things or checking on things can check and see that, Judge A does 90% and Judge B only does 50% and Judge C doesn't do it at all. Right. I don't know whether that provides. We've had some success in this country with what we call metrics, measuring things and showing judges or publicizing the measurements of what judges are doing.
you're a retired judge now, and probably you enjoy your time in promoting ADR. Can you tell us more about your view whether a retired judge should have a possibility to mediate and arbitrate cases after the retirement, and what's the role of a retired judge in terms of ADR?
I think two ways, both of which are pretty close to what I'm doing. One is to go on the panel of the private ADR companies, and certainly the JAMS model, I would think probably close to 70 or 80% of the neutrals in the JAMS offices, as you know, are retired judges.
Right.
So there's a ADR private mediation and arbitration role for retired judges. But secondly, they can do what I'm currently doing, which is to volunteer at the court. The advantage of retired judges doing mediation either for pay in a JAMS type company or as a volunteer at the court is it takes the pressure off the sitting judges from having to grapple or deal with this issue of should I go on and try the case or not. It gives an extra mediator who has judicial experience, because clients and lawyers do like the judicial experience point of view. And it gives that retired judge with the judicial experience the chance to then be the court mediator or the extra mediator at the court, and then the judge can say to the parties, well, we have a terrific retired judge for you to work with, and that judge doesn't have to worry about then should I be mediator and then should I go on and try this case or not. I've got another resource to use. The other thing that we do, those of us who are retired do, is we do wind up on panels and speaking about ADR, and we're just working today on a law firm. This may also have some relevance actually in Armenia. JAMS does there's two things I do. One, through JAMS, we do a fair number of law firm lunches where we come into a law firm and talk about what mediation is, how our company works. We're not particularly asking that they hire us, but we're certainly indicating how a company like ours can be helpful in the litigation that the company is doing. And then we also do a number of continuing legal education programs. There's one big entity called Massachusetts Continuing Legal Education that provides most of the practicing bar education programs, and they do an entire week of mediation training, and JAMS does one of the days, and David Hoffman's office does another day, and that's all done for free as a service to the bar to help train mediators.
We just briefly talked about that you actually mediate in a court apart from your role at JAMS. Can you talk, and it's actually, I think it's a pro bono mediations, right? Can you talk more, what motivates you to do this free mediations?
Part of our motivation is also, quite frankly, that we feel some sense of loyalty and want to help our colleagues. The courts are jammed with cases. I don't know what the situation is in Armenia, but we've got a huge backlog in our state courts. And if I can help resolve a dispute, I like resolving disputes. I think it's useful. I think people ought to spend more time in mediation than fighting in the courthouse. And if I can help solve another dispute and keep it out of the court docket, and the people are really poor and can't afford private ADR, then I'll do it.
As a mediator and arbitrator, I'm sure you have seen many lawyers in front of you and arguing the case before you. Can you tell us more what makes a good lawyer in terms of ADR?
I think it helps tremendously with his client relationships. To be able to say to clients, there are options, there are alternatives, there are ways we can save you time and money. Litigation has this characteristics and has this expenses, and for this particular case, I can chart out for you what those steps will be. Mediation has the following advantages, and I can chart out for you how we could fit mediation into your case. So I think it's part of the, as you said earlier, the toolkit, if you will, of a well-prepared, conscientious lawyer serving the his client in a full way. So it seems to me unwise for a young commercial lawyer, young litigator, not to go and have some training and some awareness of what mediation are. His clients can say no. He can do steps along the litigation route with his client's approval. But again, my experience since leaving the court, I'm surprised at the number of my mediations that suddenly come to me at jams because they just are stuck in the court process. And the businessmen involved I just don't want to pay any more money, either to the lawyers, to the experts, and they want to try another way. They've been burned out of the litigation experience.
Can you talk about your favorite mediation techniques?
The big technique issue, of course, for most mediators, and particularly for judge mediators who are, well, whether they're working in the court or they're working outside the court, is when to make the shift from facilitative mediation into evaluative. Judges are great evaluative mediators. They have lots and lots of trial experience. They have lots of jury verdicts in this country. They have lots of decisions they've written themselves in jury waived trials. So they have a significant body of predictive experience about outcomes. At the same time, the pure model of mediation suggests that they stay away from that. So I've developed a technique where I say to the parties in the morning, I am a retired judge, I do have a body of experience, but I want to work with you in a facilitative, sharing, exploring way to see if you can reach a solution. But if later today you decide you'd like to get some of my opinions, you'd like me to give you some evaluation of the outcomes of this case, or an evaluation of a particular motion that hasn't been heard yet, or the evaluation of a certain expert witness's point of view that you've been discussing with me, I'll be happy to do that. I will become more evaluative if you wish. And that moves you towards some of these techniques that you've heard about at jams. You've discussed it, I'm sure, with other mediators. Things like trying to get both sides to give a bracket. You don't say, well, I see you're at 10,000 and you're at 100,000. Well, we got a long way to go. But for you at 10, what's the bracket you could work with? Is it sort of 10 to 40, 10 to 50? What's your other bracket? So that's one popular technique that's used to try to move people along. And another one is to eventually get the parties to give you sort of a last and final in an envelope, and one side gives it to you, the other side gives it to you, and you try to see what if there's any this last and finals are anywhere closer to each other. As you, I think, are aware, the mediator's recommendation is another technique that's highly evaluative, and if the mediator does it and fails, you sort of lost everything because you've sort of you sort of put your best position, your best shot right in front of everybody and said, either orally in front or sometimes I do it in writing. But on the other hand, I've had basic success with mediators' recommendations. Most of the time, they get accepted in the end. And so it's a little risky. It's highly evaluative. It has to be very carefully reasoned to try to meet the interests that you've been listening to from both sides, and give both sides a sense of that they've been heard, they've been listened to. It isn't going to be the number they want or the number the other side wants, but it's a thoughtful person's independent judgment of where this ought to come out.
Let's shift the gears. I'm wondering about your arbitration experience, and particularly if you have ever had a case where you have decided a case not based on the law, but based on the principle of ex aequo bono, principle of equity.
I can think of one where I went ahead, and I think more on an equitable principle, I allowed some of the counterclaim to actually counterbalance the plaintiff. The plaintiff had the far better legal claim, and the credibility determinations went clearly with the plaintiff. But to kind of ease the burden of a full plaintiff victory, I put a little bit of I put a little weight onto and found for a portion of the counterclaim, and that could have been considered a, sort of an equitable adjustment to try to get an outcome that was perhaps fair to both, might well be accepted by both, but wasn't strictly by the law.
Can you share your experience and background in promoting mediation practice?
Of course, it's pretty much what they recommend that we do at JAMS. Be at every bar association event, every legal social event you can get to, have your card out, give it around. It's very traditional business promotion techniques that most young lawyers are probably doing anyway, to try to build their practice. I think conscientious work, careful preparation in your meet, so that you have to maintain a good reputation once you get started. So those early first mediations, prepare them very carefully, conduct the mediation with a thorough knowledge, so that nobody walks away from it saying, you know, that mediator didn't even understand. You know, he didn't even read half our documents. He didn't even understand some of the arguments that we were making. I think a friendly, personal style and openness to letting the individuals all talk during the mediation, even if you become very evaluative later in the day. I think your style, so that not just the lawyers but the clients feel that you listened and heard, and give them a chance to tell their story, even their backstory, even how their business developed and grew. There's a certain amount of time in mediation that needs to be spent just making everyone feel comfortable and participatory and respected along the way. So, I mean, getting your first case may be hard, but if you do it thoughtfully, conscientiously, well prepared, you will likely be asked again. Now, granted, mediation, arbitration, you have a problem because someone's going to win and someone's going to lose, and the loser may never want to put you on the panel again. But in mediation, if you can help, they won't go away smiling necessarily because they both gave up something, but at least they'll say that mediator really worked hard, helped us get to a solution, and I think I'd like to have them again.
When you mediate and arbitrate, it's a different role. When you do that, do you miss your role as a judge?
Well, I missed the court. I don't know that you realize we had mandatory retirement at 70 by a state constitutional amendment, which I remember voting for many, many years ago when I was a young attorney. And I thought there's a lot of mostly old men. They're all old men, and I thought they ought to leave. They ought to be retired. So I voted for it, and I never thought it would come back to remove me from the bench. And so initially, I really did miss. I thought it was too early to go at 70. 70 now is maybe 70 was more of a problem back when this was voted through in 1972. But I think a lot of changes in health and so on, and I really did not want to leave. But now I got myself so involved in mediation and arbitration and teaching and some volunteers, some nonprofit boards that I'm on. I don't miss it at all. I'm quite engaged. I'm quite engaged in a whole variety of activities.
Yeah, wonderful. Judge Cratsley, thank you so much for this conversation. I very much enjoyed it, and I'm sure for those who are interested in mediation and arbitration, this will be very helpful.
I think if there are steps that can be taken to make your new statute work, be more actively implemented and used, anything that any of us in this country can do to help we're glad to do it.
Thank you so much.
Yeah, happy to.